note of page 203, the compilation, which is a division bench order interpreting section 19 of the Family Courts Act. '30 and 31, which deal with VC Shukla.
Read it then.
In the case of VC Shukla, the appeal was directed against an order framing charged by a special judge under Special Courts Act 1979. The apex court refrained from interpreting the term interlocutory order in a special or wider sense as used in section 397 2 CRPC. It preferred to interpret the term in its natural sense, and therefore by a majority of 3:1 held, an appeal was not maintainable. The apex court considered the scheme of the Special Courts Act, which had the object of expeditious trial and quick dispatch of cases. The apex court referred to Amarnath versus State of Haryana, Madhulima versus State of Maharashtra, and the non-obstante clause in section 11 of the Special Courts Act, and held the judgments in the said case were given in the context of the court, particularly section 397(2), and were correctly decided, but would have no application to the interpretation of section 11(1) of the SCA, which expressly exclude the court. The relevant opinion of the apex court in the case of VC Shukla are as follows. So may I read it or skip notes?
That's okay.
So whatever is quoted in the note, what is quoted here?
You just see here, para number 34.
30 number.
Clause 4.
My lord.
That an order passed by special court discharging the accused.
Discharging the accused.
Yes.
Whereas 35 it says, 35 says refusing to discharge is not otherwise. It talks about para 35. Applying these tests, the order impugned, we find that the order framing charge is a purely interlocutory order, as it does not terminate the proceedings, but the trial goes on until it culminates in acquittal or conviction. It is true that if the special court would have refused to frame charges and discharge the accused, the proceedings would have terminated. But that is only one side of the picture.
We'll deal with it.
Huh?
We'll see.
And the next slide, the other side of the picture is that if the special court refused to discharge and frame charge again, then the order would be interlocutory because trial. So this is I am relying upon. The Supreme Court has considered both this part. I have read the other portions notes, para 30 and 31. Now kindly come to para 37 at page 209. I just want to reach 37. Since the interpretation of a provision relating to appeals is under consideration before this court, it would also be proper to delve on the issue at this stage. An appeal is a right of entering in a superior court and invoking its aid and interposition to redress an error of the court below. See so and so, so and so. Referred to in the so and so. In the case of Supercassette Industries versus State of Uttar Pradesh, reported in so and so, the apex court held that appeal is not a natural or inherent right and cannot be assumed to exist unless provided by a statute. In Competition Commission of India versus Steel Authority of India, the apex court, while dealing with section 53A of the Competition Act, by which Competition Appellate Tribunal has been established and which provides for appeal against orders passed by the Competition Commission against any direction issued, decision made, or order passed by the Commission under subsection 2 and 6 of section 26, but not against any direction under subsection 1 of section 26 to the Director General to investigate a case when it finds a prima facie case held that no right of appeal can be impliedly inferred. It is tried that right of appeal is a statutory right and it can be circumscribed by conditions of the statute granting it. See so and so. It is equally well settled that where the statute does not place any limitation on restriction on the scope of the width of the appeal, it shall be construed that the appeal will provide the right of rehearing on law as well as on facts. There is no dispute that an appeal is a creature of statute, and a litigant does not have an inherent right to prefer an appeal in respect of any order under a statute. These principles ought to be kept in mind in order to answer the issue at hand. Then, this is just a general proposition, and the alternative submission is so. This is the scope of interpretation on appellate provisions.
This is para 30 and 37, 38.
G 30, 31, 37, 38.
This is the judgment
of a division bench in Tinku. Judgment starts at page 187. Tinku Prasad Saha versus Suman Saha. Last.
Index is not there.
Sorry, in the index, my friend has missed it out. In the index, it is missed. I'll just make a handwritten index. Para 30,
30, 31, 36, 37 and
37 and 38. And last judgment notes are not in the compilation, which is just for a different purpose in the alternate submission. In case your lordship holds that the appeal is maintainable, para 6 of this division bench notes, may kindly see. Your lordship will permit me to convert it para 6. Para 6 is in the second page itself. Learned counsel for the appellant has addressed the court on both issues. We proceed to address the legal issues involved. Hereafter, learned counsel for the appellant has placed reliance upon the decision of the apex court in the case of so and so on the proposition that a petition under 226, 227 or a revision 115 can be permitted to be converted into appeal which lies before High Court. However, the court must be satisfied that the initial petition was not mana fide. Para 48 of the report is quoted here under. Then the Supreme Court. So, lordships can permit me to, because it is within the time of limitation.
the file within limitation.
Yes, my appeal is within. Well, the order impugned is dated on 7/10 and we filed the appeal on 22/12. So, revision is within limitation.
Even as per the
As per
SC Act.
180 days, 6 months, that is well within.
180 days is the condition
Maximum.
of delay. What is the
90
period
days, 90
prescribed?
days, 90
So
days.
it is within
Yes,
that.
yes, 90 days. So, this is my prayer.
There is only one submission I just wanted to make.
Private dispute, you are for the private
Private
dispute.
Yes. May have judgment of this mailed to court master. But I will not quote the entire judgment since only a purposive interpretation may be seen with para 73 of this judgment. This is State of UP versus Jeet Bisht.
This is Andhra Bank,
No, it's the other one.
the full bench.
No, I just mailed. But what's up?
Hold on.
I'll just have. I'm having a physical copy of this judgment.
Just a minute. ये तो 2004 11 है SCC.
2007 volume 6. This is the hard copy.
What do you want to show?
Para 73 of this judgment. Here it is.
Yes.
73. Law in its value-laden conception is not entirely endogenous in its meaning and purpose. The construction thereof also depends on the statement of purport and object. There is a spillover of the aforesaid shift in philosophy of law to statutory interpretation. Purposive interpretation of lately has gained considerable currency, which is relevant for the sake of maximizing the efficiency in respect to the point behind the rule. There may be a situation when purposive interpretation is required in the context of deciphering the constitutional mandate by invoking the notion of active liberty discovered by Justice Stephen so-and-so and American Supreme Court. This is the precise role which was exhorted by Bruce Ackerman in famous lecture. If we are to make sense of our constitution, we must cut ourselves off from the farmer's theory of democracy. The least dangerous branch opens with a second declaration of independence, not an effort at constitutional interpretation. The beginning of constitutional wisdom apparently is that Hamilton, Marshall, and so representatives. This is the crux of the matter. Is the purposive interpretation may be given. What my senior friend is citing is to say that if it is allowed, then appeal. If it is rejected, then criminal revision. So entirety is 14A, where the mandate of law is it restricts the Honorable High Court also to dispose of in a particular time-bound manner, and coupled with the fact that the provision is even if
the expeditious disposal of appeal is taken care of by the outer limit of condonation period for condonation of delay.
Yes.
So expeditious disposal is taken care of. It cannot be said that expeditious disposal is not taken care of. delay beyond a particular point is not condonable under the Act,
Yes.
which is not so in the division jurisdiction.
Yeah, it is not there. And even there is the filing, the 90 days time. Let's kindly see. I've just quoted before lines that section 4 is a provision which mandates that if the IO is in a dereliction of duty is there, he can be liable.
We are not concerned with
So
that.
I'm just indicating the provision of law. Why this amendment? The wholesome amendment is to bring a speedy justice. And even in the concept of section 14A, leadership may have the section 14A for a while, which only says not being an interlocutory order. That doesn't mean it will not include intermediary order. So that is my humble submission, and this judgment which I have cited for purposive interpretation is of Honorable Mr. Justice S.B. Sinha only, and that has been followed by 9 judges bench of Honorable Supreme Court also later.
I think I can take your lordship.
Yes. Criminal Revision number 1637 of 2023. Heard the learned counsel for the parties on the point of maintainability of the present petition. This petition has been filed against order dated 7/10/2023, passed by learned ACJ Roman 2 cum Special Judge SC/ST Ranchi in SC/ST case number 106 of 2022, arising out of Agora PS case number 285 of 2022, whereby the learned court has rejected the petition for discharge filed by the petitioner under section 227 of the Code of Criminal Procedure. An objection has been raised by the office that the present provision is not maintainable in view of specific provision of section 14 capital A of Scheduled Caste and Scheduled Tribes within bracket Prevention of Atrocities bracket Act. Hereinafter referred to as the SC/ST Act. The learned counsel has submitted that as per the provision of section 14 capital A of SC/ST Act, which starts with a non-obstant clause with regard to the provision of Code of Criminal Procedure 1973, and it provides that appeal under section 14 capital A within bracket 1 would lie from any judgment, sentence or order not being interlocutory order of a special court or an exclusive special court to the High Court, both on facts and law. The learned counsel has referred to the judgment passed by Honorable Supreme Court in the case of V.C. Shukla versus State through CBI, reported in bracket 1980 bracket close supplementary SSC 92, to submit that the provision, that similar provision under section 11 within bracket 1 of Special Courts Act 1979 was subject matter of consideration, and it was directed that against an order framing charge by special judge under Special Courts Act 1979, the Honorable Court refrained from interpreting the term interlocutory order in a special or wider sense as used by Section 397(2) of CRPC and preferred to interpret the term in a natural sense. And by a majority of 3:1 held that an appeal was not maintainable. He submits that in the said judgment, the court considered the scheme of Special Courts Act 1979 as a special case which had the objective of expeditious trial and quick dispatch of cases. And the earlier judgment passed by the court in the case of Amarnath versus State of Haryana, reported in bracket 1977 bracket close 4 SCC 137, and Madhu Lime versus State of Maharashtra, reported in bracket 1977 bracket close 4 SCC 551, and also the non-obstantive clause in section 11 of the Special Courts Act 1979 were taken into consideration, and it was held that the judgments in the said case were given in the context of Code of Criminal Procedure, particularly section 397 within bracket 2, and were correctly decided, but would have no application to the interpretation of section 11 within bracket 1 of the Special Courts Act, which expressly excluded the code. The Learned Counsel has relied upon paragraph number 7, 35 and 42 of the 7 has relied upon paragraph 34, 35, 42, 43, 45 to 48 of the said judgment. The Learned Counsel has submitted that the order refusing to discharge does not terminate the proceedings, and therefore the appeal under section 14 was not maintainable, and in such circumstances the present provision is maintainable, right? The Learned Counsel has further relied upon the judgment passed by Division Bench of this court in the case of Tinku Prasad Saha versus Suman Saha, within bracket FA number 18 of 2021, bracket close, wherein the issue whether against an order passed in terms of section 24 of Hindu Marriage Act, an appeal under section 19 of Family Courts Act 1984 would be maintainable, or a writ petition under Article 227 of the Constitution of India would be maintainable. The Honorable Division Bench held that against an interlocutory order there was a prohibition by section 19 of the Family Courts Act, and therefore a petition under section 227 of the Constitution of India would be maintainable and not an appeal. The Learned Counsel submits that Section 14 capital A of SC/ST Act, having a non-obstante provision with respect to and thereby excludes the applicability of CRPC, and therefore the term interlocutory order must be construed in its natural sense and having regard to the purpose and object of the Act, which necessitates the expression interlocutory order be interpreted in the wider sense. So, should not be interpreted in a wider sense so as to bring within its fold all such orders which are not final. It is submitted that the concept of intermediate order or a case decided which are revisable under the provisions of CRPC and CPC cannot be invoked in respect of Section 14 capital A of SC/ST Act. And therefore, the provision of Section 397 of CRPC would be maintainable against the order refusing to discharge of the offences punishable under the provisions of SC and ST Act. The Learned Counsel has also relied upon a First Appeal 18 or 21. He has in particular referred to paragraph 30, 31, 37 and 38 of the same judgment. That is all he has submitted. The Learned Counsel, appearing on behalf of the opposite party number 2, has opposed the prayer and has submitted that the very insertion of Section 14 capital A in the SC/ST Act was for the purposes of expeditious disposal of the cases. He has submitted that not only a time limit has been fixed, not only a limitation has been fixed with filing of an appeal under the said section, but an outer limit has also been fixed with respect to condonation of delay. The Learned Counsel submits that the proposition of the petitioner, the Learned Counsel submits that had the discharge petition been allowed, the same would have terminated the proceedings, and if this court finds that the refusal to discharge calls for interference, then also the proceeding will stand terminated. He submits that there is no basis to treat the two orders, namely order refusing to discharge and order allowing the discharge petition differently. The Learned Counsel has submitted that considering the object of the Act of SC/ST Act, object of the SC/ST Act, the order refusing or allowing to discharge would fall within the cannot be said to be interlocutory order, rather it will fall within the term of intermediary order. As the consequence of the order passed in the case of order passed in the matter of discharging or refusing to discharge has the result of terminating the proceedings. He submits that under such circumstances, the term intermediary, as coined and explained by the Honorable Supreme Court in the judgment of Amarnath, read with the judgment of Madhumini, is fully applicable to SC/ST Act and the impugned order is an intermediary order and not an interlocutory order. The learned counsel has relied upon the full bench judgment of Allahabad High Court reported in 2018 SCC Online ALL 2087 and has referred to paragraph 5 within bracket B paragraph 66 66 to 70, I suppose.
Well,
66 to 70. 66 to 71 and 85. And I submitted that the present revision is not maintainable. The learned, that is,
the para 95 is the conclusive.
and para 95.
95. 95 to 97.
95 to 97.
That is the finding of the.
That's that should be sufficient.
That's
The learned counsel appearing on behalf of the state while opposing the prayer of the petitioner has while opposing the submission of the petitioner has referred to the judgment passed by the Honorable Supreme Court in the case of Girish Kumar Suneja versus Central Bureau of Investigation reported in bracket 2017 bracket close 14 SCC 809 paragraph 21 paragraph 20 and 20 paragraph 20 to 23 20 to 27. And I submitted that the present revision is not maintainable. And the impugned order is an intermediate order and not an interlocutory order. Yeah. Post this case tomorrow for further dictation. I'll complete that.
well, leadership will note the.
In response, the counsel for the petitioner has referred to an order dated on sub-judgment, para number 6. A judgment passed by this court in first appeal number 49 of 2019 decided on 16/12/2020, paragraph 6. To submit that, in case this court is not inclined to accept the submission of the petitioner with regard to the maintainability of the present revision application against the order refusing to discharge, the petitioner may be permitted to convert the present revision into an appeal in terms of section 14 capital A of the SC/ST Act. He has submitted that their petition before this court has been filed within the period of limitation, even when the limitation prescribed under section 14 capital A of the SC/ST Act is taken into consideration. Right?
Yes.
To this, do you have any objection if it is converted?
No.
To this, counsel for the respondents has submitted that once it is converted, that if this court permits conversion of this petition into an appeal, then fresh stamp reporting is to be conducted. Right? कल दिखाएंगे बाकी. But I am not inclined prima facie. I am just since CAV करने से कोई फायदा नहीं है, unless unnecessarily it will linger. ऐसा कोई oral order करके छोड़ना भी नहीं चाहते हैं, because then it becomes a burden on me. बाद में dictation देना पड़ता है. कोर्ट में ही लिखा देंगे. I'll just frame it and dictate it.
Should we consider the purposive interpretation judgment also?
Respondent के submission में लिखिएगा. The learned counsel has referred to the judgment passed by Honorable Supreme Court reported in bracket 2007 bracket 6 SCC 586 paragraph number 75 to submit that that no straitjacket formula can be laid down, and the purposive interpretation is to be given as to whether the impugned order is to be treated as an interlocutory order or an intermediary order in the light of the objects and purpose of amendment to section SC/ST Act, by which section 14 capital A has been introduced.
75 minutes, my apologies. 73.
73.
Only 73.
Only 73.
Not 75.
75. 73.
That to cite Justice S.B. Sinha's judgment actually. Sir is on opposite sides, so therefore.
Judgment is always a judgment of the court.
That is it.
No judge can own a judgment,
That is it.
right?
No less.
So we neither own a judgment nor we disown a judgment. If it is overruled, we say that judgment of the High Court has been overruled. If it is accepted, it stands as it is. There is a judgment passed by Division Bench of this court regarding Family Courts Act, which says that that you need to examine with regard to maintenance, because the impugned order has been passed by referring to the Family Courts Act. So in the first half, I could not see that judgment, but that is required to be examined.
Yes.
So I'm just posted tomorrow only. I will just recall that order, because whatever, suppose I ultimately find that it is maintainable, then that order will be there. Otherwise,
so that
that issue of maintainability will be decided. Right? This is the judgment. Can you provide it to me? अभी देखें, just देखें. Okay?
I'll take note of it.
You take note of it
I'll
and
go through
advance
it
your
also.
argument, because you see, otherwise there is no occasion to recall an order. But since I have not signed it and it is a procedural matter, our registry will be guided by any order that we pass.
Yes.
Then
they did not
ultimately
point
there
it
will be
out
a
also.
conflict of order, then it will be very
Difficult. Yes.
Right?
Division
So-
bench of this order, and we are also relying on the division bench.
Once it comes to my notice, I have to take care of it.
Yes.
It was your duty also to bring it to them.
But they did not point it out. Yes,
Yes,
it was my duty.
They
but I
did
did
not. They did not. But you are expected to know the law.
We
We are not expected to know
It
the
was
law.
settled by Delhi High Court, so that is also a law.
That's right. No,
but I'll go
the
through
Delhi
the-
High Court we will not follow. If there
Ah.
is a specific judgment by our
Yeah.
court, we will not follow Delhi's.
Yes.
Isn't
So
it?
I'll go through
And
that.
whether the Delhi High Court has also considered the Family Courts Act,
Yes. 1904 is also considered. Why not appeal? Why interlocutory order?
we'll see that.
Yes.
If there is a specific order of our court, we'll follow our judgment.
So tomorrow, we shall go.
You inform the council for the other side. Somebody
State
was,
council was there.
yes, State Council was there. We have not yet issued notice so far. Right.
On Allahabad High Court also, my lord, internal orders can be filed here.
No.
Before your
इलाहाबाद हाई कोर्ट का कोई ऑर्डर है भाई, इनको भी बताइए ये ऑर्डर की कॉपी. यू जस्ट टेक दिस कॉपी,
yes.
प्रोवाइड इट टू हर ऑल्सो. आप देखिए मैडम, इट इज़ अ प्रोसीजरल मैटर, नॉट वन ऑफ केस नहीं है ना.
Yes.
यू जस्ट, वेयर इज दैट इलाहाबाद हाई कोर्ट जजमेंट?
Order is not with me just now.
यू हैव टू ब्रिंग
Tomorrow I see.
इनको दे दीजिए एक कॉपी इसमें.
Also, case item 17, 2020 or 2024.
Yes, petitioner.
My lord, in this case, the petitioner challenge is party order passed of maintenance passed by the learned family court, my lord. Where the case of the petitioner is that, my lord, the marriage was solemnized on 17th January 2016, my lord, and it was registered in the office of the registrar on 17th July 2014, my lord. Later on 19th February 2021, the difference is the arises between wife and husband, my lord. Thereafter, a complaint case 77 of 2021 was filed by the wife, my lord, under section 323, 498 and 499, 94, 406 and 34 IPC. My lord. That very criminal case is pending, my lord. Thereafter, my lord, original maintenance case was filed on 21st September.
What is your ground?
Ground is very simple ground, my lord. The maintenance petition was filed at Jamshedpur, and the petitioner has appeared through lawyer, my lord. Thereafter, my lord, the matter was transferred to the Hatsila court, my lord, and without getting and the petitioner has not been informed by the council, my lord, and thereafter he is not attended, my lord. The entire proceeding proceeded ex parte against the petitioner, my lord, and later on
Where is the impugned order?
impugned order is my lord.
154.
150. Later on it has been filed. Later on it has been filed by way of removing the fact. In this case, my lord,
Where is the impugned order? Let us see. Where is it mentioned that you appeared and then
my lord, that is at page, my lord. At page 145, my lord. Order dated 19th December 2022. The order is
when was it transferred to Ghatshila court?
as because the at that time the family court was not there, my
No,
lord.
when was it transferred to Ghatshila court?
On 7th of February, January 2023, my lord.
7th January.
Yes, ma'am. That is at page 146 of the
Page number?
146 of
146.
petition. Order dated 18th
Just a
January.
moment. Notice करना होगा.
Notice may be required, madam.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that the impugned ex parte order has been passed against the petitioner after debarring the petitioner from filing his show cause. He submits that the matter was initially filed before the Principal Judge Family Court, Jamshedpur, and on 19/12/2022, the petitioner had appeared, and he submits that the petitioner had also appeared by filing Wakalatnama as is apparent from orders dated 19/12/2022. But and the next date was fixed for filing show cause was 18/1/2023. However, prior to that date, on 7/1/2023, the matter was transferred to Camp Court at Ghatshila, in connection with which the petitioner had no knowledge, and consequently the matter remained uncontested and the interim order has been passed. यही आपका केस? Issue notice to the opposite party number 2 under speed post as well as ordinary process, for which requisites we filed by Thursday 10th. Office is directed to call नहीं सारा रिकॉर्ड तो आप लगा ही दिए हैं,
हाँ लगा दिए हैं।
कुछ ऐसा है ही नहीं. Pose this case on 29 July for final disposal. Monday है, उस दिन करेंगे.
Also case item 19, Criminal Division 225 of 2024.
One interlocutory application has been filed on behalf of the petitioner 2664/2024 for exemption.
For
Now, the
exemption.
background of the case is not the petitioner sole accused was convicted and FIR was registered under section 498 and 494. Acquittal under section 494, conviction under section 498A, punishment was 3 years by the trial court. On appeal and fine of ₹5,000. An appeal, it was modified not the sentence 3 years to 2 years, but the fine was enhanced from 5,000 to 10,000. The alleged marriage took place in 1980. The allegation is that after that, not the petitioner also married with the elder sister of the informant. This is the allegation, not in part. So, in fact, not the petitioner made a prayer for exemption on 2 grounds. On the ill health, he donated 1 kidney to his own son. Of course, he could not survive. Later on, he died. The son of the prisoner to whom the kidney was donated. And then now, he is aged about 68 years. He is suffering from kidney disease. Apart from the other allied diseases,
Petitioner is not suffering from kidney
Yes,
disease. Where do you say?
after donation,
No.
after donation of the
Where
kidney.
is that he is suffering from
Para
kidney disease?
5 is kindly see para 5. The petitioner is an old person, is at about 68 years. He is suffering from various ailments. Due to donation of one of his kidneys to his son now deceased, namely Arvind Dwivedi, he is also suffering from kidney problem. Despite such donation of one of his kidneys, the petitioner is suffering from kidney disease now because he is having only one kidney, and that too due to the old age also. He is suffering from other diabetes and thyroid. Now, the issue with regard to the rule was also a subject matter of a decision of the Honorable Supreme Court. Your Lordship has gone through that judgment also. That is 2005-15 SCC 86
12 SCC.
12.
That's it. I know.
The rule was declared to be valid. There is no doubt about it. But at the same time, if you also may kindly see the para 7 of the said judgment. It has been submitted that the statutory concerning judgment, it was observed It has been submitted that the statutory provision of section 389(3) CRPC have an overriding effect over the Supreme Court rules and henceforth, once bail has been granted to a convicted person by the trial court, this court cannot insist that he should surrender to the sentence in terms of Rule 13. That is, of course, Supreme Court. While such a submission is attractive, it does not stand scrutiny for the simple reason that subsection 3 of section 389 CRPC empowers the trial court to release a convicted person on bail for such period as will afford him sufficient time to present an appeal. The basic fallacy of Mr. Jaiswal's submission is that it overlooks the question that the grant of bail in the appeal presupposes surrender by the convicted person. The provision of section 389 CRPC and that of Supreme Court Rule 1966 are independent. Only further submission put forward is that inherent power of the court to direct listing of the case by exempting the requirement of surrender has been taken up. It is pointed out that
आपका मेडिकल एग्जामिनेशन कराएंगे
medical yes करा
रांची में आइए
रांची का
रांची में आइए
रांची में ही रहते हैं
एड्रेस तो बिहार का है
एड्रेस बिहार है अभी रहते हैं रांची जो एड्रेस वहाँ कंप्लेंट में दिया हुआ था
Where is the state? Yes, Madam Mahua. We are directing that he should be examined by a by a team of doctors headed by the civil surgeon, who
Yes.
will report as to whether he can do his basic work if sent to jail.
Yes.
Right?
That can
Criminal Revision number 221 of 2024 with IACR number 2664 of 2024. The counsel for the petitioner submits that the interlocutory application has been filed seeking exemption from surrender. He submits that the petitioner had given had donated one of his kidneys to his son, but his son could not survive, and now the petitioner is facing multiple medical problems. And it may not be able for, and the petitioner may not be able to stay in jail without any medical support. Medical support का तो
medicine
in jail बस का medicine तो आप खा ही नहीं रहे हो.
medical bedridden मतलब he is not lying on bed, so medical support की जरूरत
नहीं नहीं ठीक. Complaint है कि क्या है?
नहीं complaint नहीं है. In fact, not this. There had been several disputes between them, both of them. This is 498.
The petitioner has been convicted for alleged offence under section 498 capital A of A and 494
No, 494 he has been acquitted.
acquitted. 498 capital A of IPC. The learned counsel appearing on behalf of the state Ms. Mahua Palin. Right?
Yes.
The learned counsel appearing on behalf of the state Mahua Palin submits that the petitioner can be examined medically by a medical board constituted by the civil surgeon branch to find out about the fitness of the petitioner after hearing the counsel for the parties and considering the submission. Hearing the counsel for the parties, this court finds it proper to get the petitioner examined by a board of by a medical board headed by the civil surgeon branch, who would examine the petitioner, which would examine the petitioner and submit a report with regard to his present medical condition and as to whether the petitioner is able to attend to his personal work. The petitioner is directed to appear before the civil surgeon Ranchi on 4th of July, 24 at 11 a.m. Upon his appearance, the civil surgeon Raji will get the petitioner examined through a medical board. And let the report of the civil surgeon Raji be produced before this court by the learned counsel appearing on behalf of the state. She will file an affidavit? No, not required. In a sealed cover. In a sealed
What
cover.
is the report?
In a sealed cover. Was this case on 18 July.
For final disclosure, item 1, WPI 2126 of 2016 allows that entry.
This is a part-heard matter, was heard on the last occasion,
Yes.
and I shall continue in a very brief manner just to refresh.
Yes.
The instant writ petition has been filed for issuance of writ of certiorari for quashing the order passed by this award passed by the Central Government Industrial Tribunal. The award starts at page number 79.
In both the cases, same award is
Same award has been passed because the presiding officer has not even whispered a single word
That's
on
right. He
the
has not whispered anything
Yes.
we have seen.
and
No evidence has been discussed. Did
No
you need evidence?
yes, we are ready to give
No,
evidence.
did you need evidence?
No, we didn't lead evidence. The workman, and this is a case of no evidence. The workman as well as the management,
None of them
none
led
of them led evidence, and the your leadership would directly come to the operative part of the award. It is at page number 81. The second line, that it is true, but as per section 33 within bracket 2, the management ought to have obtained approval from the tribunal to justify their action and must pay 1 month's salary at the time of dismissal. Next, asking for approval from the tribunal relating to action of the management would not lighten the dignity of the management. The Honorable Apex Court has clearly observed that while a dispute, whatever sort is pending before the tribunal, approval must have been obtained from the tribunal to justify the action and a decision to that effect reported in such and such. Considering the facts and circumstances, I hold that action of the management in dismissing the complainants is illegal and not justified, and hence the workman to be treated continuous in service from the date of the dismissal along with all the
So
benefits.
para 3 is the case of the workman.
Yes.
Para 4 is the case of the
Management. 4, 5 and 6. 4 and 5. 6 is
Yes.
again a case of the
6 is
workman.
again workman submission.
Yes. And the operative 6 में operative insert हो गया, that it is true वहीं से, और 7 or 8 operative का full portion. Now, your leadership, the law has already been settled by your leadership while sitting in division bench, and they said on the last occasion I had handed over the
446.
compilation.
446 वो compilation नहीं मिला हमको
Compilation
दोबारा.
नहीं मिला, हम दूसरे कॉपी उसकी थे.
That it has to be decided on merits.
मेरिट्स उसका डायरेक्ट हम पैराग्राफ पर आते हैं. है तो जजमेंट बहुत सारा, हम उतना टाइम नहीं लेंगे, डायरेक्ट जजमेंट पर आते हैं. और ये सुप्रीम कोर्ट ऑर्डर लास्ट डेट को हम नहीं दे पाए थे, जो एसएलपी डिसमिस हुआ था, ये उसका पॉइंट.
Para 16 and 17.
योर लीडरशिप एलपीए वाला जो ऑर्डर है,
Para
वो
16, 17.
11 से 11, 12, 13, 14, 15, 16, 17 वर्कमैन के इशू पर आ गया. 2 लाइन हम केवल इसमें से पढ़ लेते हैं.
Yes.
13 में देखा जाए, 11 से ही पढ़ रहे. However, in view of the above said finding, the court is in complete agreement with the finding of the learned tribunal as well as the learned read court that complaint under section 33A of the Act was maintainable on account of violation of 33. However, mere violation of section 33 does not automatically lead to setting aside order of dismissal, which is evident from the 2 judgments relied upon by the appellant. ये दोनों judgment 12 में quoted है, उसके बाद 13 that it is held in judgment reported in such and such that this section 33A has a definite purpose to serve, that is to provide direct access to the tribunal and thereby a speedy relief instead of seeking a time-consuming procedure for seeking a reference under section 10A of the Act. Now, it's very important here. In the complaint under section 33A, the employee will succeed only if he establishes that misconduct is not proved and not otherwise. Thus, in the complaint, the employee will have to prove his case on merits. If it does succeed in establishing so, it will relate back to the date on which the dismissal order was passed by the employer as if it was inoperative. The remedy is independent of penal consequences in such and such. 14 अब आया जाए. In Satya Prakash, the appellant, the employer has applied for necessary approval. It has been held that complaint having been adjudicated as a reference as required under section 33A of the Act and the misconduct was proved, there was no question to hold that
That's what
allegation.
we have seen.
और 16 का दो लाइन देख लीजिए. 16 में लिखा हुआ है कि it has to be treated as a
Industrial
reference.
dispute.
और फ्लैग B and C पर जो इसमें दो
उतना
जजमेंट्स,
काफी नहीं है.
ये जो एक्सट्रैक्ट था लास्ट थिंग आपने बोला था कि इसमें जो एक्सट्रैक्ट है उसका सुप्रीम कोर्ट का जजमेंट भी लगा देना, वो मैंने लगा दिया है. और एक लाइन जस्ट लास्ट सबमिशन. This penalty order of dismissal along with forfeiture of gratuity was passed after holding a full-fledged domestic inquiry. तो उसमें फ्लैग E में जजमेंट ML सिंगला वर्सेस लगा हुआ है, उसमें जस्ट एक पैरा. Para number flag E, para 50. The first error was that it failed to decide the validity and legality of domestic inquiry. Since the dismissal order was based on domestic inquiry, it was obligatory upon the labor court to decide the question as a preliminary issue as to whether the domestic inquiry was legal and proper. Here, the presiding officer has not even whispered a single word on correctness, legality, propriety of the domestic
That
inquiry.
the presiding officer has not treated it as a reference.
Reference.
He has said that there is violation and hence.
Yes.
So far as violation is concerned, that is also disputed or not disputed.
So far as violation.
Violation in the sense that you have instituted a proceeding during the pendency of a reference. So you were required to obtain only post facto approval? Or
Yes, we were required only the approval under section 33(2)(b) because they were not connected with the that was with respect to overtime. Reference 138 of 1997 was with respect to overtime, and here, as the statute says, that kindly have a look at
Yes.
the statute. 33(2)(b) during pendency of
So the required approval was in terms of section 32,
it
33
was
2B.
होना चाहिए था, मैनेजमेंट ने लिया नहीं.
हाँ.
ये
लिया है कि नहीं लिया?
नहीं लिया है, नहीं लिया. No approval application
So
was
therefore
there.
that it was to be decided like a
Like a reference. Like
Automatic reinstatement नहीं हो.
नहीं होगा.
ठीक है ना? यही ऑर्डर कर देते हैं, भेज सकते हैं वहाँ पर. It has to be decided as a reference. It is an admitted fact that the required approval has not been taken.
Yes.
And it was an unconnected dispute.
Unconnected dispute.
दोनों का सेम ऑर्डर सेम अवार्ड है कि
जी.
Common
award
award.
same.
Common award.
Common award.
Okay.
Award start.
WPL number 2126 of 2016 with WPL number 2118 of 2016. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that a dispute with regard to overtime allowance. General dispute था?
General dispute.
General dispute with regard to overtime allowance was pending before the learned Labour Court.
For the central government industrial.
Before the learned Central Government Industrial Tribunal number 1 Dhanbad in reference case number 138 of 1997. And during the pendency of the dispute, the respondent was subjected to disciplinary proceedings on account of unconnected charge leveled against the respondent, which were primarily on account of corruption,
Misappropriation of grain, bungling of grain,
Misconduct.
gross misconduct.
gross misconduct in the nature
Sort
of
of misappropriation of food grains.
misappropriation of food grains. The learned counsel submits that the matter had no connection with the overtime allowance, and therefore a post facto approval was required to be taken in terms of section 33 2b of Industrial Disputes Act. The learned counsel further submits that a complaint was filed by the respondent in both the cases under section 33 of the Industrial Disputes Act, alleging violation. He submits that the respondent in both the cases were subjected to disciplinary proceedings, and after completion of the proceedings they were terminated.
Dismissed.
They were
Dismissal.
dismissed. They were dismissed from service. The learned counsel has submitted that in case of allegation regarding violation of section 33 of the Industrial Disputes Act, the same is required to be treated as a reference and is required to be decided in the same manner as a reference under section 10 of the Industrial Disputes Act. This means that there is no concept of automatic reinstatement of workmen merely on account of violation of section 33 of Industrial Disputes Act. Okay?
And just one thing, there can't be any automatic setting aside of dismissal order for non-compliance of section
He
33.
submits that there cannot be any automatic setting aside of order of dismissal on account of non-compliance of section 33 of the Industrial Disputes Act. He has referred to the judgment passed by this court in LPA number 446 of 2019, decided on 4th of August 2023, and has referred to paragraph number 11 to 16
11 to 16.
of the said judgment. He submits that the special leave petition, the special leave to appeal in fact is C number 22595/2023 arising out of the said judgment has been dismissed by the Honorable Supreme Court. The learned counsel has also submitted that even the legality and validity of the domestic inquiry was required to be considered by the learned court as a preliminary issue, but the same has also not been done. The learned counsel submits that the impugned award is otherwise also cryptic, inasmuch as there is no evidences were led.
No evidences.
Inasmuch as the case has been decided without any evidence from the side of either parties.
No merits of the matter have been considered.
And the merits of the matter has not been discussed. The learned counsel submits that the matter be remanded back for fresh consideration in accordance with law. The learned counsel appearing on behalf of the respondent in both the cases have submitted that the petitioner has violated the provisions of section 33 of the Industrial Disputes Act, but certainly the same was required to be decided as a reference, which has not been done by the learned labour court, and therefore the matter can be remanded, but appropriate time frame may be given so that the dispute can be taken to a logical end. यहाँ पे कोई है अभी?
नहीं, अभी कोई नहीं. CGIT आसनसोल के प्रेजाइडिंग ऑफिसर इंचार्ज में चल रहे थे, वो भी सुपर एनवाइट कर गए हैं. अभी कोई नहीं है.
To this, counsel for the petitioner has submitted that, as on date, the post of Presiding Officer, Industrial Tribunal, Dhanbad, number 1 Dhanbad is vacant. Okay? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the impugned order arises out of alleged violation of the provisions of Section 33 of the Industrial Disputes Act. In the judgment passed by this court in LP number 446 of 2019, it has been held in paragraph 11 to 16 that in case of a complaint filed under Section 33/33 capital A of Industrial Disputes Act, and in case of violation of the provision, the same does not automatically lead to setting aside the order of dismissal. Rather, the dispute is to be decided as if it was a reference under Section 10 of the Industrial Disputes Act. Para 11 to 16 of the said judgment is quoted as under. A copy of the order passed by the Honorable Supreme Court dated 17/10/23 arising out of the aforesaid judgment has been produced by the counsel for the petitioner, which reflects that the special leave petition against the said judgment has been dismissed. The perusal of the counsel for the parties have also submitted that no evidence was laid before the learned court, and the impugned order also reflects that there is no discussion of any evidence. The impugned order, the order of dismissal has been set aside by only referring to the fact that there was violation, वो भी finding नहीं दिया है.
नहीं दिया है, वहाँ एक जगह दिया
By only referring to the fact, by only alleging that there was violation of Section 33(2)(b), a violation of Section 33 of the Industrial Disputes Act. In view of the aforesaid judgment passed by this court in LPA number 446 of 2019, it cannot be disputed that alleged in case of dismissal, in case of any complaint made under Section 33/33A of Industrial Disputes Act, the dispute with regard to dismissal is required to be decided as if it was a reference under Section 10, meaning thereby the legality and validity of the departmental inquiry as well as the other provisions of Section 10 was required to be followed, and the case was to be decided on the basis of evidence to be led by the parties. The impugned judgment, the impugned award is in 8 paragraphs. Para 1 mentions about the reference. Para 1, 2 and 3 are formal in nature. Para 4 refers to the case of the workman. Para 5 refers to the case of the management. Para 6 refers to certain submission made by on behalf of the workman. And in continuity in paragraph 6 itself, it has been mentioned that as per Section 33 within bracket 2, the management ought to have obtained approval from the tribunal to justify their action and must pay 1 month's salary at the time of dismissal. And then in white paragraph 7 and 8, white paragraph 7, it has been observed that asking for approval from the tribunal will not belittle the dignity of the workman, of the management. And finally, in para 8, the dismissal order has been set aside. This court finds that the impugned order neither follows the provision of the Industrial Disputes Act as interpreted by the Honorable Supreme Court in numerous judgments and has been also referred to in LP number 446 of 2019, nor there is any discussion, nor the same has been passed after taking evidence. Accordingly, the impugned order is perverse, which is hereby set aside. The matter is remitted back to the Central Government Industrial Tribunal number 1 for passing fresh order in accordance with law after granting appropriate opportunity to both the parties in accordance with law.
And also
Since
leading
the-
evidences.
sorry?
Or leading evidences also.
And it will be open to the parties to lead their evidences. It is observed that the learned Central Government Industrial Tribunal number 1, and that once the presiding officer assumes charge of Central Government Industrial Tribunal number 1, he shall make all endeavours to expeditiously dispose of the matter. And the parties are directed to cooperate for expeditious disposal of the case. These petitions are accordingly disposed of commonly.
In serial number 2, there are 2 IAs. Both the IAs have rendered infructuous. Serial
Both
number
the
2.
IA is closed.
Closed.
That's it.
Item 3, WPC 5013 of 2019.
Right. This case, before starting my argument, I just give the brief facts of the case. A partition suit lordship was filed. When a partition suit was
Who's
filed,
for the other side? Are you appearing? Ready? Yes.
a small point is there, lordship. A partition suit was filed. In a partition suit, lordship, a schedule was given containing 7 plots. I am the plaintiff and they are the defendants from a same family. Since lordship, partition suit family has to be same. Now, lordship, what happened? During the judgment of the appellate court found that one of the plots is exclusively belongs to the other side, and therefore that is not liable for partition. One of the plot, that is 1196. Then, lordship, during the
At the
pendency,
time of judgment.
lordship,
Prior to judgment or post judgment?
in the judgment, lordship, in the appellate court's
Okay.
judgment, appellate court came to the finding that one of the
They
plots.
must have been claiming that property.
Yes,
to be
yes.
exclusive
On that
property.
basis, lordship, it was said
That's
that it is their self-acquired or whatever, lordship. I am not on that.
All right.
That is admitted. Now, lordship, 6 plots remains. After the final degree was prepared, a second appeal was also there, lordship. That is also part of the story. And second appeal was consequently withdrawn by us, and therefore now the appellate court's judgment remains. Now, what happened, lordship? For the preparation of the final degree, the Pleader Commission goes to the place of the property for demarking the lands. During that course, lordship, he finds that 3 plots which has been mentioned in the schedule does not belong to the family at all. For which, lordship, we also had given an application earlier for deleting those plots. Somehow they were not deleted. Now, Lordship, in their deposition, who is respondent number 8 herein, he has deposed as PW7 that I have also annexed. He also admits that these plots does not belong to the family. Therefore, Lordship, since if the report of the pleader commissioner should have been accepted by the court that since these plots does not belong to the family, which is not being objected by the plaintiff nor by the defendant, even the pleader commissioner came to the conclusion that these plots does not belong to the family. Therefore, it cannot be partitioned. Otherwise, it will give several other complications in the suit. 21, 97, 96 petitions will have to be filed by the persons who are not even interested in the property, not the parties in the suit. To meet out all those things, Lordship, we tried to get it deleted. Now, Lordship, what the court says is since the final degree or the pleader commissioner cannot go behind the degree. That is correct, Lordship. What our submission is that since, Lordship, it is a partition suit, the entire family is saying that this is the property does not belong. Somehow wrongly it was inserted in the schedule, and therefore, Lordship, it was also ordered to be partitioned, and I was given 21% of the share. That is also not in dispute.
Now the share will be recalculated.
No, not recalculated, Lordship. What happened? It was again sent back to the pleader commissioner. Since the pleader commissioner report was that these plots cannot be partitioned, the court did not accept that. Court said that no, you are not liable to say all these things. You again go for the pleader commissioner's report, give a proper and final report. Now, Lordship, it is still in that stage. Now, pleader commissioner has not gone the second time because all the parties are here, Lordship, and before the honorable court. Now, the problem, Lordship, is that if the pleader commissioner goes again and say again those things, and because of this difficulty, Lordship,
Who is the owner of those properties?
our ancestor, Lordship.
No, those 3 properties.
It has come, Lordship, in the pleader. I'll show that. The name has come and also
Some
the
third
deposition
party,
of the
some third party.
उनकी जरूरत ही नहीं है. Now, Lordship, one question
it
was
belongs to whom?
some other person, Lordship.
Some other person.
हाँ, he is not related to the family. It is
in
agreed.
whose possession?
Those persons, Lordship, who
Those
are the
persons,
descendant of the yes, Lordship. नाम
Somebody
उनका
else.
सबका दिया हुआ है. Names of all the persons have
The
been given.
problem क्या है इसमें?
Problem ये है कुछ इसको नीचे कोर्ट में ऑब्जेक्ट किए in spite of their own submission
Are
in
you
their
still
deposition.
objecting?
No, I'm not objecting. I'm not objecting.
अब नहीं कर रहे.
नहीं ठीक है. So now you say there are ways and means of dealing with that dispute. Now both of you are in the same platform so far as these 3 or 4 properties are concerned, and you do not want that this should form a part of the partition amongst both of you. You do
And the
not
final
want
deal.
any further.
Yes, yes.
You don't want any further complication with any third party, right? No, it is neither desirable on both of
Yes.
you, nor it is proper also.
Yes.
It is not proper once it comes to you. So why don't you go for mediation and draw a proceeding before mediation? हो जाएगा काम उससे?
हाँ, काम तो
That-
है.
उससे काम हो जाएगा? क्या करना? बताइए.
Again, the problem will arise. The court will say that since these things are in the blend, are in the final preliminary degree, and therefore we are handcuffed. Since it is not there, judgment of the Honorable Supreme Court is there.
even if any judgment attains finality, Supreme Court तक final होगा.
Even if.
Is there any bar
No, not at all.
in
Because it is
mediating and
still-
coming to
Yes,
a settlement amongst
If
yourselves?
that is indicated, Lordship, in the order, Lordship, we are.
No, you have to tell us as per law. We
Yes,
have
yes.
to proceed as per
Since,
law.
Lordship, what I am submitting, since it is a suit between the private litigants, they are at any point of time, they can compromise the things. And here, Lordship, it is not the matter of compromise. It is the matter of truth which has come out in the Peters Commissioner report. And also it was revealed to us later on. For that, Lordship, we have also filed an objection. इसको जो delete कर दिया जाए. Somehow the court below did not delete it, and for against that order, no one approached the
So
appellate
you
court.
can have a mediation and say that your division of share would be confined to only these
Only three.
properties, and these properties you are not interested in.
Yes,
any kind
that
of
is the
division.
Peter Commissioner's report.
No.
That is the report also.
But some order has to come.
Yes,
from-
yes, some
from
order has to
somewhere.
come.
Is there any legal impediment in doing
Not
this?
at all, Lordship. Since even by order of this Honorable Court, excising power under Section 152 of the CPC, read with 151.
No, no.
I have
You
got
see,
that
when it
judgment
goes
also.
to mediation, we do not need to invoke anything further.
Yes, yes, yes. Nothing.
Isn't it?
Yes.
Is it possible? Can it be done?
See, I also don't have any objection. The only problem is the application was filed under section 152. Whether an order can be passed under section 152 correcting those mistakes is the
No,
problem.
we are not
But
going
if
to
it is sent
correct
for
any
mediation,
mistake.
then it is not.
There is no question of any correction. The matter will be sent for mediation,
Yes.
and you will agree in
Yes.
the mediation. Suppose the good sense prevails upon you, you will agree that you are not interested in any kind of share or any kind of partition with respect to plot number such and such.
It is better,
Simple.
Lordship, by
Then
this.
the matter will come to
Yes,
this court. We will
yes,
record
Yes,
an
yes.
order to that effect, and then we'll ask the court to proceed accordingly.
Lordship,
Yes,
Can't
that
it
can be done.
Because we are also agreeable with this. We don't have any.
I'll send it to mediation.
Mediation.
I will not say anything more.
Yes,
Because
yes, only for
के लिए
mediation.
I will
Yes.
just say that parties have agreed for mediation.
Mediation.
ठीक है?
Any date may fix, Lordship, and
I will fix it. WPC number 5013 of 2019. Counsel for the parties submit that the matter may be sent for mediation. The properties involved, most of the properties, कुछ बोलने का जरूरत नहीं. The parties belong to have common ancestor.
Common sister.
ठीक है?
Common ancestor MD Ali.
Sorry.
MD Ali. That can be.
लिखने का भी जरूरत.
हाँ,
मोहम्मद अली.
Mohammed.
Namely Mohammed Ali. The parties are directed to appear before the secretary, Jharkhand State Legal Services Authority on कब appear होंगे बताइए?
20 July, 20th July, Lordship. Because some parties, Lordship, are living outside.
On 20th of July.
20th, 20.
20
Lordship.
of July 2024 at 11 a.m. and upon their appearance, the learned secretary Jhalsa shall appoint a mediator to consider the grievance, shall appoint a mediator
For resolving the issues.
for resolving the dispute between the parties. The report of the mediator be filed before this court by 29th July.
इतना जल्दी तो नहीं हो पाएगा.
इसमें क्या ऐसा करना है? आप
नहीं,
लोगों
हो सकता
दोनों
है.
को जानना है. कितने लोग हैं? बहुत ज्यादा लोग
हो
हैं.
जाना चाहिए.
बहुत ज्यादा लोग हैं.
ठीक है. बहुत लोग तो बहुत ज्यादा है, लेकिन इसमें 2-3 पार्टी भी आएंगे तो
नहीं.
many persons are there.
It's
Lordship.
very.
They all
Is
cannot come.
everybody appearing before this court?
Everyone.
Is everybody appearing before this
Therefore,
court?
Lordship, this has come for their
I am
admission.
hearing for 10 to 15.
And for 8.
Others might have received Lordship and
Somebody you might have received some instruction. वहाँ पे हो सकता है कोई instruction लेके आए that to represent somebody. I don't know whether it will work out in that manner. Is it permissible that one party will represent the other party?
no, Lordship, what happens if the persons are not appearing here? They cannot say that we want to appear there.
That's right.
Because since the notice have been issued, they have received the notice, chosen not to appear. Therefore,
Chosen not to appear.
must not have appeared. Lordship. Only some parties are appearing. Concerned parties will go, Lordship.
And before the this pleader commissioner also, all of them are not appearing.
Family is there, Lordship. The pleader commissioner goes to the house. Obviously, the persons who are present, they are there.
I just wanted to know if there is any legal
No,
complication.
not at all, Lordship. Since the parties who are appearing here in this court, Lordship, they are only required to appear. Even, Lordship, the persons who are not appearing here, they cannot say that we wanted to participate in mediation, but I did not appear in the writ application. It cannot come like that.
In mediation, if something happens, then under such circumstances, they might come and say that this mediation is not binding on them, the modification is not binding on them. What will it be?
They can always say all those things, Lordship. If they want to delay the matter, Lordship, they can say all those things. If they are not appearing here also, not appearing after receipt of the notice,
They are not appearing before the.
because Lordship, now the
also.
matter is pending there. Their advocates have been appointed by everyone.
When this application was filed, they did not even object or contest.
This application has not been objected. Only the person who objected are here.
All right, let us see what happens.
Yes, yes.
29 तक नहीं होगा.
उस पे एक डेट और है.
ठीक है. 29 के बाद 5th August.
3rd
August तक हो जाएगा.
2nd of August.
Mediation report be filed before this court by 2nd of August. ठीक है. Propose this case on 5th of August.
Lordship.
अगर आप लोग आपस में भी डिसाइड कर लें इतना कि at least so far as you are concerned you will not lodge any claim with regard to that property.
If they are agreeable, Lordship, I don't think they will do anything.
Now, suppose whosoever are appearing over here, if they also say that they will not lodge any claim and in the mediation may come that this property does not belong to the family.
It is already in record. It is out of the record.
कोई सब चीज़ के लिए mediation act बना.
This is the best possible thing which could have been done.
Otherwise तो बहुत मुश्किल है.
हाँ फिर तो अपील होगा फिर तो unending litigations are.
मतलब we are preempting certain kind of litigations.
Yes.
वो सब include.
Let us go step by step. Let us see what happens.
Item 4, WPS 625 और 2020.
अपना appearance दे दीजिए. आप लोग advocate on record है ना? Because mediation has to go with consent of the parties.
Please go. Please against
Before my friend begins, I've got an objection that इसमें MA फाइल होना चाहिए था.
हाँ ये तो maintainable नहीं है. रिट कैसे चलेगा? मिसलिनियस अपील फाइल
सेक्शन
होता है.
13 में अपील फाइल होता है.
आप वो फाइल करिए नहीं चलेगा. WPL number 625 of 2020, counsel for the parties are present. Counsel for the respondent has submitted that the present writ petition is not maintainable as the impugned order is an appealable order in terms of section 30 of the Employees Compensation Act 1923. To this, counsel for the petitioner has submitted that withdraw करना है क्या करना?
Withdraw.
Seeks permission to withdraw this writ petition and submits that liberty be reserved with the petitioner to take appropriate steps in accordance with law. He has also submitted this in view of after hearing the counsel for the parties and considering the nature of relief sought for in this writ petition. This court finds that the petitioner has an efficacious remedy under section 30 of the Employees Compensation Act 19 has an efficacious remedy in terms of the provisions of Employees Compensation Act 1923. Accordingly, this court is not inclined to entertain this writ petition, which is accordingly dismissed as not maintainable. However, liberty is reserved with the petitioner to take appropriate steps against the impugned order in accordance.
Section 14.
वो तो section 14 लगेगा या?
Section 14 फाइल है, 14 फाइल कर दीजिएगा.
एक सेकंड.
Notice
Notice हम आपका डिले का पूरा. This writ petition was filed on 13/2/2020 against the order dated 30/11/2019 passed in WC case number 11 of 2017. ये हमारे प्रेयर में भी रहेगा. ठीक है, हो गया आपका डिले कंट्रोल. सेक्शन 14 लगाइए.
नोटिस इस पे लगा हो चुका था. पार्टी भी अपीयर हुए.
आपके प्राइवेट पार्टी है.
Yes, respondent to one.
The learned counsel appearing on behalf of the opposite party number 2 has also submitted that the petitioner has a remedy under section 30 of the Employees Compensation Act. वहाँ पे नहीं बोलेगा नहीं मेंटेनेबल, इसीलिए आपका लिखा दिए. चलिए. एक सेंटेंस कॉमा फुल स्टॉप का भी बहुत मतलब होता है, तो लाइटली मत लीजिए. अपना अपीयरेंस दीजिए आपको. एक्सपार्टे के अगेंस्ट में भी अपील ही होगा क्या?
Any award, term is award.
सेटिंग असाइड भी उसी में होता है.
Item 5 WPS 5114 of 2021.
इसमें मिस्टर मनोज राम है वो,
हाँ, क्या होगा?
उनके फादर का डेथ हो गया 2 दिन पहले.
कब रखना है बताइए. सिनॉप्सिस आ गया है इसका. नहीं, क्या मैटर था बोल दे. क्या मैटर है?
मानोड इनके द्वारा छिपाया गया है कि ये नेम्ड अक्यूज्ड है सरिया पीएस केस नंबर में एंड ही वाज ऑन प्रोबेशन ड्यूरिंग दैट पीरियड.
तो
He was during the probation in which he was dismissed. उनको सब्सिक्वेंटली बाद में जनरेट किया गया कोर्ट में, लेकिन सिमिलर इशू पे माय लेडीशिप का जजमेंट है.
जजमेंट क्या जजमेंट?
पारा 21
दया इससे कवर्ड है केस.
सिमिलर इशू, उनका भी सेम ही इशू है.
तो ये मेरे पास क्यों आया हुआ? WPS पार्टनर है क्या? Assignment. The learned counsel for the parties are present. Counsel for the petitioner seeks adjournment by submitting that the counsel for the petitioner, that the arguing counsel is not available on account of personal reasons. Counsel for the state has filed a list of dates and has relied upon a judgment passed by this court in WPS number 510 of 2009 decided on 22/11/2022. Since the petitioner is seeking adjournment, pose this case on. बताइए कब रख दें?
2 weeks.
$29 July
Fine.
for final disposal. उसको ना टैग कर.
Item 6 WPL 5266 of 2021.
Please petition.
Heard in the last week, I have also given a written note of argument. The respondent had to reply. They had not appeared on the last day. This is that case relating to over unauthorized absence from service for 27 days.
That's right. Yes,
Your
are you there?
Ladyship, on instructions from Mr. Suraj Kishore sir, I am here. I have prepared a list of dates and arguments.
You have given your synopsis, right?
Yes, the petitioner has said.
Yes, let me hear you. Or you just argue for some time and then you say. Your main argument is that your documents have not been considered.
Our main argument is that the respondent workman has been constantly changing the stand regarding absence. In the written statement, he says that initially I was out of Ranchi for 2 months and therefore I was unable to attend the office, and that is also the reason for not responding to the charge sheet and notice. But in the very next paragraph, he contradicts that stand by saying that I had not remained absent for 2 months. In fact, I remained absent for only about 15-20 days, and on 21st March itself, 17, I returned, and on 22nd the charge sheet was issued, and I kept on going to the office, but I was not allowed to join. So the court has framed the issue, although court has not decided, court has framed the issue regarding validity of inquiry, but not as a preliminary issue. At the time of final award, it has been framed separately, not even with the main issues. In that, the court, while believing that he was not there and the notice was not properly served, the court has held that there was no inquiry. The court has also disbelieved the inquiry on the ground that there is another termination letter which is based on the standing order which provides for loss of lien in case the employee remains absent, 11.2.7. So that is one of the grounds, but then the Labour Court also extensively goes into the inquiry, the details of which were brought on record, including the proceedings of the inquiry, the charge sheet, the personal clerk who went to his house to serve the notice, his statement is also there, everything was marked exhibit. But the reason for not entertaining is one, that the court believes that he did not have sufficient notice and therefore did not participate in the inquiry. And secondly, the court says that in the examination in chief, he has made a statement that he was out of Ranchi because there was some case of criminal nature, the particulars and documents of which he never supplied, either in the inquiry or subsequently or in the Labour Court. But the court says that since there was no cross-examination, which is a hyper-technicality, and I have also relied upon a decision which is there in the compilation, that the strict rules of evidence, though the general principles apply, but in industrial adjudication, the strict rules that only one statement that since there is no specific cross-examination on that would absolve the workman from proving the justifiability, which is also one limb of our argument, because once the absence itself is unauthorized, and admittedly unauthorized, he went without leave. He says, I never gave any oral or written communication.
This argument is beyond the contours of permissible interference. So merely because the fact remains that he has been cross-examined, and he has not been cross-examined on material fact. So these are absolutely reappreciating evidence. We are not going to examine cross-examination and examination in chief and compare fact. You have to show me something very glaring to set aside the argument.
So we have said that the perversity is because the different dates and the constant shifting of the stand which the court fails to take into notice. The court, while relying upon or basing its findings, takes into account those different dates, all of which are mutually inconsistent and self-contradictory.
So he has taken self-contradictory stand, and therefore the court did not iron it out.
The court did not iron it out. The court does not explain also. In fact, the court gets trapped in these shifting stands and returns findings against the management without any explanation as to how can these be reconciled. His statement of remaining absent for about 2 months and then contradicting and saying, no, I returned back and I tried to join, but I was...
Did he make a statement that he returned back within the period of 2 months?
Yes, that is there in the written statement itself. Also
Is it evident from the award?
In the award, there is no discussion. In the award, when the finding regarding inquiry comes, para 27 onwards, there they say that since he was outside, there was no sufficient notice. Okay. But then the learned court ought to have relied upon paragraphs 4 and 5, 4, 5 and 6, which are the contradictory statements.
4, 5 and 6 of WS?
Of the WS of the workman, which is annexure 1.
Para 4, 5, 6 of WS, right?
Yes.
Annexure
he
1.
Says for about 2 months he was not there, and then in 5 he says that serving a letter dated 22/3/2000 to the workman's wife, asked him to submit his explanation regarding his absence since the workman was out of station, hence he could not submit his explanation. So he admits that Even the charge sheet he is admitting that it was received by his wife on 25/3, but he was outside. And then in paragraph 6 he says that the workman returned Ranchi on 21/3. This 18 is a misprint because he says that since 22/3/17 he was regularly going in paragraph 6. 18 it is nobody's case that it was.
Paragraphs. Page number?
Page number 27 of the brief, writ petition. Annexure 1 is the written statement.
Let us see what is his stand in the written statement.
Yes. So page 26.
One is formal.
One is formal.
Initial appointment is 4/11/2006.
Yes.
Then termination is
347.
3/4/17.
And then from 4, 5 and 6. These
yes,
are.
can you read it?
4 is the workman was due to family dispute assaulted, and with a view to protect himself, he left Ranchi for about 2 months. And under this compelling circumstances, he could not attend his duties from 9/3/17 to 21/3/17 only. So this is again, it cannot be 2 months. Neither he could inform the company about his absence. So that is his admission. Next paragraph, that the management serving a letter dated 22/3/17 to the workman's wife on 25/3/17 asked him to submit his explanation regarding his absence. Since the workman was out of station, hence he could not submit his explanation.
Okay,
So he is admitting that
knowledge,
25th.
He had knowledge.
25th he says knowledge.
Okay.
And in the say next paragraph 6, that the workman returned Ranchi on 21/3/18. This is an apparent typing mistake because it is nobody's case 18. Everything happened in 17 including termination. And since 22/3/17 he was regularly going to his workplace, but the management did not allow him to do any work. So there are three.
Okay. And what is the period of absence as per the charge memo?
The period of absence is, as per the charge memo, it was till the date of dismissal.
Yes.
That is in the supplementary.
What is the date of charge memo?
Yes. The first charge sheet is 22/3/17.
Okay.
This is page 47. It was marked Exhibit B.
First charge. Then he joined the inquiry. No, he remained absent.
He remained absent throughout the inquiry.
Okay,
that is
wait,
admitted.
just a moment. What is the final date of final order?
The punishment order is termination is 5/4/17. In fact, 3/4/17. There are two punishment orders, and therefore the court disbelieved because the first one is based on 11.2.7, which is loss of lien, but then the management had filed a supplementary WA saying no, we did not do it only for loss of lien. We also initiated a disciplinary proceeding, and that 5/4. So both those are exhibit. The 5/4 is exhibit M. And 3/4/17 is exhibit G. So, and that is why the labor court disbelieved, because there were two punishment orders, exhibit G and exhibit M. And it says that this exhibit G does not mention about any inquiry. But having said that, the learned labor court does not completely disbelieve and does not return a finding that there was no inquiry. In fact, it delves into the inquiry and says that he was not given opportunity. So, though it casts, there is some doubt which has been shown, but it has not been completely disbelieved because there is a specific finding.
If we accept your submission, what is the consequence?
According to us, we had also prayed that it is a case of remand because these are glaring. The ultimate perversity is because these if all these documents and these shifting
If these
stand,
sequences and shifting stand of the respondent is not taken care of, therefore,
the court below has
that-
therefore failed to separate the chaff from the grain and has got lost in the maze of facts and has selectively relied upon these different dates while recording findings against us.
yes, what do you say?
Your Ladyship, first of all, this statement has been made on 19/11/2018. This notice says that at the point when the show cause was given, served upon his wife,
No,
he
no,
was
your,
aware.
it is your written statement.
Yes, it is my written statement.
Yes. You say that show cause was served, that the management serving letter dated 22/3/2017 to workman's wife asked him to submit explanation regarding his absence. Since the workman was out of station, hence he could not submit his explanation.
But this does not reveal that he was aware. And the Labour Court has relied upon a specific clause in the certified standing orders, if I may point out, at page 88.
What
This
is that
paragraph
clause about?
30. Clause 21.4 of the certified standing order of the Waxpol Industries Limited is relevant on this point, which provides as under. In case the workman who is to be issued the charge sheet
Page number?
or page 88, my lord.
Yes.
Paragraph 30.
Huh.
Clause 21.4 of certified standing order of the Waxpol Industries Limited is relevant on this point, which provides as under. In case the workman who is to be issued the charge sheet or suspension order is present on duty, he shall be served with the charge sheet by hand in presence of at least one other employee of the company. In case of an absenting workman, the charge sheet or suspension order shall be sent by registered AD post or under certificate of posting at the last known address of the concerned workman available in the company. I
So what
find
is
no
the purpose
evidence.
of issuance of this notice? It is an admitted fact that the notice was served upon your wife.
Upon my wife, not on me.
Okay.
And it is a settled position of law that if where a power is given to do a certain thing in a certain way, then it must be done in that manner and no other manner. It is on this basis that the Labour Court has come to a conclusion that the workman was not given an opportunity to present his case. And secondly, if I may point out, after conducting the inquiry, there is an inquiry report. The termination letter is dated 3/4/2017, and the inquiry report is also dated 3/4/2017. This has not been served upon the workman. An inquiry report also notices that at paragraph 2 of the inquiry report, Your Lordship, let me
So
find
where
out.
do you come to this finding that this was not served on you? So that was not your case in the written statement.
Because Labour Court found out that there was not proper service of the proceedings upon the workman according to the certified standing orders. Therefore, the Labour Court came to a conclusion that principles of natural justice have not been complied with.
Where is the written statement
This-
of the management?
This is at page 32.
You just filed this two-line written statement.
This is supplementary written statement.
Where is that?
After 2/1.
Where is that?
This is page 32.
38.
Page 38.
Paragraph 2. That with regard to the submission of the workman in paragraph 4 and 5 of his rejoinder, it is stated that firstly he was issued show cause, then inquiry officer was appointed in respect of the departmental proceedings to be conducted on the aforesaid misconduct. The inquiry officer fixed the date to secure his version twice, but due to the reason that he was away from Ranchi during that period, he did not appear before the inquiry officer, nor any communication from his side could be made available to the inquiry officer. They are themselves saying that he was away from Ranchi.
What is this photocopy of the show cause?
They have annexed the show cause.
That is show cause, not reply to show cause.
No. This is at page 47 that they have annexed. This is the charge sheet they are saying. This is dated 22/3/2017.
Should have been show cause notice. They have
Yeah. Show cause notice.
Thereafter, the termination letter is at page 52. This is dated 3/4/2017.
Page 50.
Page 52. With reference to the above, it has been observed by the management that since you are receiving the letter, neither you have communicated us nor you have showed your interest to get in touch with us in any manner whatsoever. This is, they are terminating me.
Is it not contradictory on the part of the Labour Court to say that firstly the court says that there was no domestic inquiry, and simultaneously the court says that even if there was a domestic inquiry, isn't it contradictory?
No. Labour Court is saying that there are two limbs of the arguments that the Labour Court has considered. If your leadership may see this letter of termination,
yes.
This refers to show cause letter number so and so dated 22/3/2017. This does not refer to the domestic inquiry.
Okay. How does that make a difference?
This makes a difference because if your leadership may look at page number 59, this is termination of Mr. Shatrughan Karmali.
You are therefore advised to be presented at domestic inquiry on 31/3/2017. It is mentioned in this only. In page 48 only it is mentioned. You are therefore advised to present at the domestic inquiry on 31/3/2017.
Correct.
So there was an
But
initiation of the domestic inquiry.
But Labour Court is looking at it from 2 points of view. This letter, termination letter, is based upon only the show cause.
Date of termination is 3/4.
And it is all Labour Court is also considering if at all.
This is not the order of termination.
This is the order of termination.
Page 48.
52.
Page 52.
An inquiry report is also dated 3/4/2017, same date on which the termination letter has been issued. And thereafter on 5/4/2017, the GB Roy Chaudhary, Director Works, has advised to terminate Mr. Shatrughan Karmali. If I may read out page 59. Refer to your telephonic conversation with me on 3/4/2017 regarding termination of Mr. Shatrughan Karmali. As communicated by you regarding inquiry report of the inquiry officer, I had authorized you to issue termination letter without any further loss of time. The formal letter will follow in pursuance to my above order. The formal order to the effect is being addressed to you, which is as follows. We refer to your charge sheet letter number dated 22/3/2017 issued to Mr. Shatrughan Karmali, as also refer to the subsequent domestic inquiry proceedings conducted by Mr. Chandreshwar Dayal, Manager Production and R&D Loops and Inquiry Officer. After going through his report on inquiry and observation, we find it justified and relevant to terminate Mr. Shatrughan Karmali from his services. Under the aforesaid circumstances, we advise you to terminate Mr. Shatrughan Karmali immediately after receipt of this letter and initiate necessary action in order to struck off his name from the muster roll of the company.
We just come to page number 86.
Your Lordship.
Last portion. In the above circumstances, it can be said that either there was no domestic inquiry or the order of termination was not based on the domestic inquiry.
Correct.
Right? So, merely because the order of termination is not referring to any domestic inquiry, isn't it? So,
The Labour Court has
after
proceeded
having
on both
recorded a
layers.
finding, this finding, para number 27, you read please, even if it is assumed that there was a domestic inquiry.
Correct.
So there has to be a clear finding of the Labour Court, whether there was a domestic inquiry, there was no domestic inquiry. He was supposed to look into these documents, whether
He has looked into it. After that, he has come to a conclusion that principles of natural justice have not been followed, and after that, he has proceeded to examine whether the misdemeanor alleged against the workman is made out or not.
let us read para 27.
Yeah, Your Worship. If,
Page 86.
Even if it is assumed that there was a domestic inquiry, an order of termination was based on the findings of the inquiry report, as the management has brought documentary evidences of holding domestic inquiry and has examined to Mr. Chandreshwar Dayal as management witness 1, who allegedly conducted domestic inquiry. On scrutiny of evidences available on the case record, I find no proof of personal service of notice, show cause, etc. in connection with domestic inquiry to the workman on the case record. No copy of article of charge is available on the case record, and there is no evidence that any letter of initiating the domestic inquiry, appointment of inquiry officer, article of charges, and memo of evidence was served to the workman. Further, there is no evidence that copy of inquiry report has been supplied to the workman. On appraisal of evidences on point of validity of domestic inquiry, I find that Exhibit C is a letter dated 29/3/2017 of the inquiry officer addressed to the workman Mr. Shatrughan Karmali, directing him to appear in the domestic inquiry on 31/3/2017 at 2 p.m. But there is no evidence of service of the letter to the workman. Exhibit D is another letter sent by the inquiry officer to the workman Mr. Shatrughan Karmali, mentioning therein that since he had not appeared in the inquiry on 31/3/2017, hence he is directed to contact the inquiry officer within 2 days. Again, there is no service report. The management has filed copy of gate passes dated 29/3/2017 and 31/3/2017, Exhibit E, to show that the office peon, namely Vijay Mahato, had taken above letters for service to the workman, but the said messenger in Exhibit F has clearly mentioned that the workman was found absent from his house and workman's wife has refused to take letters dated 29/3/17 and 31/3/2017 by saying that she could not read letters. In Exhibit L, inquiry report also, it has been mentioned that the messenger through whom the letter was sent to the workman returned the letter and said that Mr. Karmali was absconding from his home for more than a month in connection with an incident of criminal nature. This messenger is of the management. The inquiry officer, management witness number 1, in paragraph 13 of his cross-examination has admitted that he has sent notice to workman on 31/3/2017 and deposited his report on 3/4/2017. Therefore, from evidences it is very much clear that the domestic inquiry has been held in the absence of the workman and without considering the side of workman. However, the learned counsel for management has tried to argue that opportunity of defending to the workman was given as the inquiry officer directed the workman to twice to appear before him. But from inquiry report itself, it is proved that the letter issued to the workman by inquiry officer were returned unserved by the messenger, who told that Mr. Karmali was absconding from his house for more than a month in connection with an incident of criminal nature. I find that the management has filed copy of a show cause notice dated 22/3/2017 Exhibit P, by which explanation was sought from Shatrughan Karmali within 24 hours from receipt of the notice. Learned counsel for management has vehemently argued that show cause notice dated 22/3/2017 was served to the workman's wife on 25/3/17.
What was the reason for your absence?
There was some dispute because of which I had been beaten up and I was running away. As has also been noticed by the management in their inquiry report, I was absconding because of criminal nature of the inquiry.
Para number 49. Para 49.
29.
49.
On scrutiny of evidence, last paragraph. On scrutiny of evidences and materials brought on the case record, it is proved that the workman Sri Shatrughan Karmali was appointed in the Wax Coil Industries Limited by appointment letter dated 4/12/2006, Exhibit 1, and his appointment was effective from 1/11/2006. And on the date of termination, that is 3/4/2017, the workman was permanent employee of the Wax Coil Industries Limited, having continuous service for not less than 1 year. Further, it has been proved that the workman has absented himself from his duty without any authorized leave and without any information to the management since 9/3/2017. And further, neither of the parties could bring the material facts required for award of back wages. The workman has failed to bring convincing evidence that he was not gainfully employed anywhere during the relevant periods. Considering the nature and the charges against the workman as well as the facts and circumstances of this case, this court is of the view that the workman is entitled to 50% of the total back wages for the period from termination/dismissal till his reinstatement. Hence, issue is decided in favor of the workman.
The finding is that you have remained you absented without any
informing
leave
the management.
and without any
Correct.
information to the management.
Correct.
That finding is there.
Your leadership.
Therefore, under such circumstances where such finding is there that you have absented without any information and without authorized leave, where is the question of payment of 50% packages?
Your leadership, the question that the management had to decide in the domestic inquiry was that whether my absence was justified or not.
What stand have you taken? Where is the finding that you had given some justification for your absence? Is there any finding regarding that?
Regarding my absence.
You see, your absence is not in dispute, right?
Correct.
You never gave any intimation, and it was unauthorized is also not in dispute, right? Is there any finding in the award with regard to any material to show that you had some reasons for being absent?
Your leadership, I had made amendments and I made a statement in my deposition that is there, but the
What is
management
there?
never.
No, what is there? What was your averment? You see, the notice could not be served is good, right? What further averment have you made justifying your absence? There should be some finding in the Learned Labour Courts award also that you had given some justification for absence. Where is that finding?
Your leadership, I have made a statement in my written
You
statement.
forget about the written statement. We are on the award. Is there any finding returned by the award? You see, you had
Paragraph
ample
41.
explanation for, you see, you had admittedly once you do not participate in the inquiry and the absence is admitted, right? And you stood terminated, right? As per the provisions of their own rule, you lose your lien. As per their own rule, you lose your lien on being absent for a continuous period of whatever days. Right? So, where is the finding by the Learned Labour Court regarding your reason for any absence?
This is at paragraph 41. The case of the workman is that he had left his house due to family dispute and
This
was.
is fine. This is your case. Where is the finding?
This is the award.
That's right. Award has its own parts. It has case of the respective parties. Where is the finding that you had left for some reason? Is there any finding to that effect?
In paragraph 41 itself, 41 and 42, the Labour Court has given a finding about the absence.
Absence is admitted, isn't it? You dispute the absence. You don't.
No, I'm not disputing the absence. I'm
Your
saying that,
only contention is that you had sufficient reasons for absence.
correct.
So what evidence have you led to that effect?
These are the depositions from my end and my and another co-worker that has been examined.
Yes.
Apart from that, if your leadership is looking for documentary evidences,
No, I'm not looking for any documentary evidence. What I'm looking for is a different angle altogether. In the domestic inquiry, two things have to be seen. One is whether the absence is admitted or not, right? And secondly, whether the absence is proved or not. And secondly, whether there was any reason for absence. If one has a possible explanation for absence, then under such circumstances, the order of dismissal is uncalled for.
but that burden is upon the management to show that there was an unjustified absence.
No, firstly, you have to show
I have
your
to
reason.
plead. I have to plead that I have.
Therefore,
a justified reason.
in a circumstance where you had some justification for absence, but the absence is admitted, are you still entitled for 50% back wages?
I'm entitled to 50% back wages because the management has wrongfully terminated my services
The management is taking
without following the principles of natural justice.
How much is the gap? What is the date of termination is 2017. When is the award passed?
Award is dated
4/10/21.
4/10/21.
October to 4th of
And there's a judgment on the point of back wages. That if there is a finding recorded by the labor court that the dismissal was unjustified, then back wages may be awarded after seeing there are principles defined. But
We'll continue tomorrow. It's already 4:30. We'll continue tomorrow. This judgment you are relying upon, this Dipali Hindu. You are referring to para 38.6?
Your Ladyship. Uh, 38.5.
It starts from page number 324.
Your Ladyship.
Para 38.6.
That one short case, serial number 42 may be taken up tomorrow. 42, very short case.
It will come in the next one.
Tomorrow
WPL number 5266 of 2021, the arguments of the parties has remained inconclusive. Post this case tomorrow for further hearing. ये वाला जजमेंट इनको वापस कर दीजिए, ये जजमेंट हमको दे दीजिए.
serial number 42 is possible tomorrow.
नहीं हो सकता है सर, अगला हफ्ता आएगा आप कर दीजिए. मेंशन करेंगे तो हम कर ही देते हैं, मेंशनिंग तो हम अलाउ करते हैं. 10:30 बजे तो आप कभी आते नहीं, इसीलिए मेंशन नहीं कर पाते. हमको पता है, ठीक बोल रहे हैं ना.
38 नंबर था, उसमें 10 साल हो गया, मजदूर कोर्ट जजमेंट हुआ था मिनिमम वेजेस में.
10 साल हो गया.
हाँ 10 साल, 14 में जजमेंट.
तो इम्प्लीमेंट नहीं हुआ अभी तक.
अभी तक नहीं.
तो आप एग्जीक्यूशन नहीं कर रहे हैं.
38 तो बोल रहे हैं वो नॉट बिफोर मी.
38 नॉट बिफोर मी.
42 next
38.
I will not.
आप किसका आपका है 38
38
नॉट बिफोर मी.
42 next week I am not here. इसलिए
तो अगला उसके अगला भी कर.